I think it is clear to believe in the power of ideas.
Fresh thinking of the Manhattan Institute.
Thank you very much. As you've heard, Ken Feinberg is one of those people who, as they say, needs no introduction, but I think it's particularly important that he receive one. First of all, because he probably likes them. And also because the achievements that he's had that seem to make an introduction unnecessary actually also present a danger that it may be useful to dispel in an introduction, a danger that I think it's been one of his singular achievements to avoid. First, the part that Ken assuredly likes, which is the achievements. After racking up an impressive array of honors at the University of Massachusetts, where he earned his BA, NYU Law School, he clerked for one of the most well-regarded judges in the history of the New York Court of Appeals, Stanley Goldstein. He served as an assistant U.S. attorney in the criminal division in the Southern District of New York, which is where I first met him. He went on to be special counsel to the Senate Judiciary Committee, administrative assistant to the late Senator Ted Kennedy. He was a partner of the K. Sheila firm, founded his own office in 1993. Notwithstanding those achievements, it's what he has done since that has established his reputation, beginning with his work with Judge Jack Weinstein in helping resolve the Agent Orange litigation. Those cases grew out of the use of Agent Orange as a defoliant in Vietnam and resulting claims based on its toxic effects on the soldiers who came in contact with it. He's been tapped by administrations of both parties to allocate funds to victims of two major national traumas, the September 11, 2001 terrorist attacks and the oil spill in the Gulf in 2010. The principal stipulation that he placed on his service in administering the 9/11 fund, in addition to the requirement that he have complete authority, was that he receive no salary. He was also responsible for designing and implementing the claims process for victims of the Virginia Tech shooting in 2007, also without pay. In addition to those high-profile assignments, Ken has mediated and overseen the settlement of many mass tort and other multi-party disputes. In fact, I think it's no exaggeration to say that if he did not, in fact, invent the discipline of dealing with cases affecting large numbers of people, he has both popularized it and raised it to a level never attained before, to a point where he's become identified in the public mind, I think, and here I include the collective mind of the legal profession, as the person who can be relied on to do justice in seemingly intractable crises, whether they're intractable because of their sheer size and diversity, or because they present moral challenges like valuing human life and suffering that seem beyond human capacity and yet have to be dealt with. So what could be dangerous about such a person? Well, what's dangerous, I think, is captured in the statement by Justice Felix Frankfurter in one of his opinions, where he wrote as follows. He wrote, "We do not sit," and by we he meant the Supreme Court, although he might just as well have meant the entire legal system in this country. "We do not sit like a caddy under a tree dispensing justice according to considerations of individual expediency." What he was saying there is we don't have a system of caddies, village elders, whose justice depends on their authority and nothing else. We operate under a system of knowable rules, transparently and evenly applied. And that is a danger that Ken has managed to avoid almost entirely in every assignment that he has undertaken, and in all of them collectively. He is certainly a wise man, but he has not exercised simply the authority of a wise man. He has submitted himself and his determinations to criticism based on rules he has made specific and applied rigorously. To me, that's one of his singular achievements. And yet I have to tell you that as someone looking in from the outside, the choice of rules to apply when there are competing policy interests to be served, when what's fair doesn't immediately leap out and present itself with childlike simplicity, and the articulation of those rules to the satisfaction of, if not everyone, at least almost everyone, has been sheer genius in the cases that he's handled that I've had occasion to look into. I think we can find a clue to how he does that in his personal background and life. He was raised in Brockton, Massachusetts. He has a fine family to whom he's very devoted. He's an avid Red Sox fan. He's the president of the Washington National Opera and is a scholar of music in general and opera in particular. That's a clue to the fact that he is fully tuned in to what it means to be a human being. You want to make someone who's good at what Ken Feinberg does, start with somebody who's good at being a human being. Ken is accomplished as a human being, and it's my great pleasure to introduce him, Ken Feinberg.
Thank you very much. I'm honored to be here today at the invitation of the Manhattan Institute. I must say, I want to thank Judge Mukasey for those words. I do like to hear those words, it's true. I want to say one thing about the judge. America, as a nation, every once in a while, we confront a crisis in this country. It can be international, it can be domestic, local. And we're very, very lucky when during a particular time of crisis, somebody steps up and fills the void and does the job and doesn't care about the plaudits of the crowd. Michael Mukasey, I am confident about this, will go down in American history as being at the right place at the right time when the Bush administration, in a time of crisis, luckily and with great skill, appointed the judge as Attorney General of the United States, much to the benefit of our people. And today, even though he's no longer Attorney General, he is the conscience of a school of thought as to how we in America should protect ourselves consistent with our principles. So we will always be, I think, in the Attorney General's debt for his service to the United States, not only as a judge, but as the Attorney General of the United States. I am under some pressure here today for three other reasons. Just as the general has served with distinction, Sheila Birnbaum is here today. Sheila Birnbaum has taken on the assignment of a reenacted 9/11 Victim Compensation Fund passed during the lame duck session with obstacles and challenges that I didn't have to confront, like a limited budget, which I didn't have to deal with. And for Sheila to be here today and to be smiling and in good spirits, we are very, very fortunate that Sheila's taken on this assignment because it's going to be one real challenge to compensate responders today for what happened 10 years ago. And we're lucky that she's here. And then there's one academic I must introduce. There's one academic I must introduce who is sort of the academic voice long before all of this was fashionable, and that's Professor Peter Schuck, who's here today from Yale, NYU, Fordham. He travels around. But it's Peter's writings about Agent Orange and other matters that have sort of guided me and guided a lot of others dealing with mass torts and mass tort reform. And he's here today, and I thank him for his presence. And finally, the most pressure, my son, the lawyer, is here. You try giving a speech with your son, your oldest son in the audience, a practicing lawyer here in Manhattan for Credit Suisse. So I got to be on my toes here because he'll be calling me right after this talk with some comments about Dad, well, you know. Now, in about 15 minutes, I will give you the thesis with some examples, and then we'll take questions from a very sophisticated audience here today. What is the thesis? Every once in a while, very rare, every once in a while in America, there is a national tragedy that captivates the American people and our policymakers. It doesn't happen very often. It happened with 9/11. It happened with the BP oil spill. It happened at Virginia Tech. It doesn't happen that often. But every once in a while, policymakers decide the conventional way of doing things. You hire your lawyer, judge and jury. Doesn't work. We don't want the inefficiencies, delays, and uncertainties of the conventional way. So, Congress will pass a law 11 days after 9/11 saying, if you don't want to go to court, don't go to court. The taxpayer will pay for compensation in lieu of tort. Come on in, waive your right to sue, and we'll give you a tax-free check. You don't have to. If you lost a loved one on 9/11 or you were physically injured on 9/11, we've passed a law. You have a choice. You can sue the airlines, the World Trade Center, the security guard companies, Massport, the Port Authority. Go ahead. Boeing. Or come right in within a matter of weeks. Get a tax-free check totally paid for by the taxpayer. That's an example. Everybody took the money. Over 33 months, the 9/11 fund, 97% of all the eligible families who lost a loved one came into the fund. 94 people decided to opt out and sue, and every one of them settled within 5 years thereafter. There was never a trial. I mean, that's an example of my thesis. BP is even more amazing. More amazing. After the oil spill, the President of the United States brings BP into the White House, and the BP walks out and announces, we will voluntarily front $20 billion to pay victims of the oil spill. It's voluntary. You can go sue. There's an MDL proceeding, a multi-district panel proceeding in federal court in New Orleans, but if you'd rather go into this fund, we'll pay for it. And you can get compensated that way. And we agree it's got to be somebody chosen to do this who will be not beholden to BP. And we've talked to the White House and everybody, let Feinberg do it. In the next month, February 27th, is the first trial that's scheduled arising out of that oil spill. By that time, the Gulf Coast Claims Facility will have already dispersed about $6.5 billion and received releases from about 225,000 people. So I think what the administration and BP had in mind, let's avoid Exxon Valdez, let's avoid 20 years of litigation, frankly, a tribute to the judge in New Orleans and the lawyers, that they've even got the first trial up as soon as less than 2 years from the time of the spill. But meanwhile, this facility has distributed this money. Now, what does it tell you? Well, it tells me a few things. One, it's rare indeed that you opt for one of these alternative type programs. You can put on one hand the number of times in the last 25 years that these alternative schemes have been promulgated and implemented. Two, nothing's going to change, in my opinion. Now, the Manhattan Institute may say, you know, when it comes to mass litigation, there ought to be a better way. First, I'm not sure that's right. I'm not sure that in most situations, the conventional legal system works pretty well. Not perfect, but it works pretty well. But I don't want to, I'm a gracious invitee here. I'm a gracious invitee. They did feed me here. So let me say this to the Manhattan Institute and to this audience. The real dilemma is, even if you think there ought to be a better way, I don't see it. I don't see it as, I think it's tilting at windmills. The legal system in this country is so ingrained in the fabric and history of our country. The idea that there'll be some major reform that will change the way we go about resolving disputes in this country, I think is highly, highly unlikely, even if you think it's a good idea. So I'm all for debating this. Maybe at the margins there are improvements that can be made. But I'm not sure major improvements are required. And even if they are required, I'm dubious you can politically implement reforms that major that fly in the face of over 200 years of our history. So good luck. If that's your goal, and I wish you well, I'm just not sure. Now, there's a third problem with this. There's a third problem that plays into the hands of reformers. It really does. Peter Schuck has articulated it better than anybody, publicly and privately. Be careful about these programs like BP and 9/11. Because when you establish special programs for just a few people, what about everybody else, you see? What about egalitarianism, equal protection of the law, everybody treated similarly? You should have read some of the emails I got when I was administering the 9/11 Victim Compensation Fund. Dear Mr. Feinberg, my son died in Oklahoma City. Where's my check? Dear Mr. Feinberg, I don't get it. My wife died in the basement of the World Trade Center in the original 1993 attacks committed by the very same people. Where's my check? And it's not just terror, you see. Dear Mr. Feinberg, can I come and see you? I don't understand something. Last year, my wife saved 3 little girls from drowning in the Mississippi River, and then she drowned a heroine. Where's my check? You see, when you set up these programs with great fanfare and you announce it's only for certain types of people, everybody else fend for yourself the way you normally do. But for these people in Louisiana and Florida, you don't have to go through Exxon Valdez. BP, the money's here, $20 billion. File, get your money, and you're home free. Now, if it's a moratorium claim arising not out of the spill directly, but because the government imposed a moratorium on deep water drilling for 6 weeks, you're not eligible. It's got to be from the spill. So, you moratorium people, sorry. You oil spill people, here, plenty of money, come on in. It doesn't sit well with people down there. Any more than 9/11, the 9/11 fund didn't sit well. Sheila's got plenty of headaches now. Sheila's got plenty of headaches. She's going to have to decide who's eligible to take a limited pot. There's only a limited pot this time. And she's going to have to define eligibility criteria. Well, Sheila, I'm a resident in Lower Manhattan. I wasn't a first responder, but I breathed all that guck, and now I'm sick. Pay me. Well, I only have so much, so these are the problems. So from a philosophic point of view, the reason I say this is an argument that the Manhattan Institute seeking reform should address is because maybe the problem is that these aberrations shouldn't be aberrations, that there ought to be maybe a generic way in mass litigation to provide an alternative mechanism, not just for oil spills or terrorist attacks, but generally across the board. Now, that's a tall order, I must say, but that's an argument. That's why Peter Schuck wrote that he thought the 9/11 fund, with all of the compassion and all of the generosity, was not a good idea. You're singling out certain people for a fast-track check, and not only a check, fast-track attention. And be very careful about that. The other thing to be very careful about, and the general passed on this, mentioned it in passing, in a way, implicitly. These programs, like BP and 9/11, Congress and the administration, they delegate to one person this type of authority. Sheila has it now. No appeals, no checks and balances. You're a wise man. You do it. You design it with some generic provisions. You design it, you implement it, you administer it. It's voluntary. If somebody doesn't like what they get, they don't have to take it. They can go into the regular route, the regular channels of dispute resolution. I'm not sure as an administrative law matter, it's sound public policy to be delegating to one person the authority to design and administer these programs. There's no appeals. The 9/11 statute expressly prohibits appeals to the courts. So in a way, it's not lawless, but in terms, everything's relative. It's certainly less prescriptive and circumscribed than the normal way that we resolve disputes. So those are a host of reasons why I say 9/11 fund, I think it was sound public policy. I think it worked. We did exactly what Congress intended. It was a tribute to the American people's compassion. Just don't do it again. The BP oil spill fund, don't worry. I can't see that program being replicated very often, if at all. You show me an example in American history where a company, weeks after the explosion, fronts $20 billion and says spend it wisely, and we'll turn it over to an independent third party. I don't know of any situation where a company, without any finding of liability, without any judicial imprimatur at all, a handshake with the President of the United States says, come one, come all, $20 billion, you see. I don't think it's likely that there'll be situations where other companies will front that type of money in order to clear out claims. Maybe they should. It may very well be in their interest. Maybe the pharmaceutical and the chemical companies should look at the BP example as a model for consideration. But you're tilting at windmills if you think that's going to happen. So I think these are aberrations. They're one-offs. They should be studied not so much in law school, but in classes in history. They're history. They're interesting historical responses to unique public catastrophes that galvanize policymakers to do something different. I mean, the administration in BP knew post-Katrina debacle, we better do something different. They did. Now, in all of these, my last point, in all of these examples I've been involved in, there's always unique problems. In BP, listen to this. BP made the mistake of announcing a liquidated amount, $20 billion. Huh. You announce $20 billion, they will come. I've received in 17 months about 1.2 million claims from 50 states, 400 from New York, and 35 foreign countries. Why not? There's 20 billion. Let's take a flyer on this thing. Let's try. You know, why not? Then there's the problem in BP of proof. Mr. Feinberg, I lost $100,000 fishing. I couldn't fish. They closed the fishing grounds. I need $100,000. Okay, what do you offer for proof? Do you have tax returns? No. I don't have any tax return. Don't worry. I don't need tax returns. What do you have to document? Well, here's my corporate profit and loss statement. Here's my checkbook. Here's my wage earning receipts from the state of Louisiana. What about that? Looks good to me. I think you're right. I don't need tax returns. That's pretty good. Now, I'm going to send you a check for $100,000, and with it, I'm going to send you a 1099. Well, I waived that. You can't waive a 1099. I'm going to have to send you a 1099. I withdraw my claim. You're going to withdraw a check for $100,000. You think the IRS cares about? You're not. I'm telling you, You're sending me that 1099, I'm withdrawing the claim. And he withdrew the claim. A terrible problem down there. The volume of claims. Now, some of them, I've got claims from dentists, chiropractors, veterinarians. One guy in Norway made rope for fishnets in the Gulf. Files a claim, and he has a physical injury claim. We check on that. He was going to the post office. He slipped and broke his leg. Filed a claim for a broken leg as part of his claim. So, I mean, you get all of these. The volume of claims is a big problem, you see. That was the problem with 9/11. You had a law degree. Nah, you need a divinity degree to deal with 9/11. One story from 9/11. One. And then we'll take questions. A lady comes to see me. We gave everybody, Sheila knows this, we gave everybody a hearing who wanted a hearing. Half the people wanted a hearing to come in to validate the memory of a lost loved one. They didn't come in to talk about money. They came in, they wanted to talk about somebody who traumatically disappeared on 9/11. Dust. Lady comes to see me, 24 years old, sobbing. I thought she was going to collapse. Mr. Feinberg, I lost my husband. He was a fireman at the World Trade Center. And he left me with our 3 children, 6, 4, and 2. He was Mr. Mom. Every day that he wasn't home at the firehouse, he was home teaching the 6-year-old how to play baseball, teaching our 4-year-old how to read, reading a bedtime story to the 2-year-old. And what a cook! He cooked all our meals. He was the gardener around the house. He was Mr. Mom. Mr. Feinberg, the only reason I haven't jumped out a window to join him is he left us with the 3 kids, 6, 4, and 2. But Mr. Mom is gone. My life is over, no matter how much money you give me. She leaves. The next day, I get a telephone call from a lawyer in Queens. Mr. Feinberg, did you meet the lady yesterday with the 3 kids, 6, 4, and 2? Yeah, I did. Mr. Mom? Yeah. Now, Mr. Feinberg, listen to me. You got a tough job, I know that. She doesn't know that her husband had 2 other kids by his girlfriend in Queens, 5 and 3, you see. I represent them in the 9/11 fund. He didn't die with 3 surviving children. He died with 5 surviving children. But I'm sure you'll do the right thing. Click. See, he hangs up. Do you tell her? Do you tell her? That's what keeps you up on these jobs at 3 a.m. Do you tell the woman about the 2 other kids in Queens? Yeah, see. Now, I didn't tell her. I didn't think it was my place. I didn't know all the facts. I'm not a family counselor here. I'm trying to get money out. And she has a memory of her husband, so we cut 1 check, paternity and everything, that was a given. We cut 1 check to the widow and the 3 kids, and we cut a separate check to the girlfriend as guardian of the 2 kids. Now, it's 10 years later. I'm sure that they must know about all of this now. But those types of problems, you see, are what really keep you up at night, not whether this is sound public policy or whether it's an aberration. It's problems like that. So I think that every once in a while, these programs come down the pike, and there's a confluence of political forces. Policymakers decide that we ought to do these things. And I'd like to think that these programs, rarely invoked, work. I think the BP program has worked. I think in the 9/11 fund, neither of those programs will ever be replicated, I don't think. Never be replicated. But I think they worked. I think they exhibit the type of legal creativity that occasionally policymakers say is very, very sound public policy. Just don't do it too often, because it raises all of these philosophic and practical questions about special treatment. So that's sort of 20 minutes, and now let's throw it open for questions. Yes, sir.
Wait until
Jim, you're in charge. You're directing traffic here.
Please wait until you're called upon and then address the audience. Tell us who you are. Roger.
Hi, my name is Roger Moak. I'm an arbitrator here in the city. Mr. Feinberg, can the Manhattan Institute take advantage of your wisdom by asking you what smaller fixes to the broken legal system you think are within the realm of possibility?
Well, that's a that's a tough question in terms of what changes there should be made. I think probably there should be some changes made in terms of class action litigation. Judge Weinstein's just spoken out about the need to make sure that in mass aggregate litigation, where lawyers represent hundreds or thousands of people, there's got to be more democratization in making sure that these class members, doesn't have to be a class, aggregate members, have more understanding of what it is that their lawyers are purportedly representing them about, and whether or not it's a good settlement, a bad settlement, they want to be part of this. I would say the one area where Weinstein and others have spoken out is the need for what we call more democratization of mass litigation, so that people who are impacted by such litigation aren't just cogs in the wheel, but know more about the nature of the litigation, why they're included, why they don't have to be included, why they should be part of litigation or a settlement, why they don't want to be part of that. That's one area that, in the mass area, that I think is worthy of reform. Democratization of mass litigation. That's just one example.
Yes, Stanley.
Stanley Goldstein, just a comment. You mentioned you didn't need a legal education, but a divinity degree to do your job. Those of us who work in Midtown after 9/11 use Fifth Avenue very often. And almost every day, in front of St. Patrick's, there was a funeral with muffled drums, a widow, 32, 34 years old, 3 or 4 kids, every day, day in and day out. So my heart is out to you having to deal with those people, and I'm glad you were there.
Okay.
Christy in the back.
You mentioned that you paid out about $6.5 billion for BP and that the fund was $20 billion. Wouldn't that provide kind of a track record incentive for companies to step up and do this more often and actually kind of not be so singular as you're saying?
Much too reasonable an approach. I mean, my experience is that companies will hold on to their money and will defer compensation. Maybe legitimately. I'm not saying that companies are being greedy or wrong on this. I'm just saying that my experience is the time value of money and the political desire and the legal desire. Before we will pull that trigger, we want more findings of responsibility, if not liability. We want to know who else might come to subsidize payments, might not just be us. There are a litany of reasons why the Exxon Valdez precedent of 22 years of litigation and growing is the rule rather than the BP exception. Now, BP had a lot of reasons, I think, why they decided to think out of the box. Think out of the box. Creative thinking out of the box. But I don't think it's likely, I'm just making a layman's point of view, I read the newspapers, I don't think it's likely that you'll see the BP largesse or the BP approach emulated by others. Not to that degree. That is very unique, it seems to me.
So again, please identify yourself. That was Christy Kendall of Fox News. Here's her boss, John Stossel.
John Stossel. Just the 94 people who sued outside your system, I know the settlements may be secret, but do you get a sense, did they get more than they got from you? And just also, you say it's unlikely that this would repeat or would be a good idea to repeat. If there were another Oklahoma City, would it not be better to have a fund than the cumbersome tort system?
Sheila resolved all 94 of those cases as a mediator at Judge Hellerstein's request. She pulled it off. Every one settled. Every one. I think, my own personal view, I don't know what those people got. In response to the question, I think probably maybe some got more, maybe some got less. There are attorney's fees that come out of those settlements. There's the costs associated with the litigation. There's the time value of money. There's the tax-free nature of the 9/11 payments. So I'm not sure that you can surmise one way or the other. You can make any general comment about those 94 settlements. As to the next time, look, this is Peter Schuck's point, I guess. The next time, if Congress decides, or a White House occupant decides, John's right. We ought to have, for the Italian cruise disaster, with that boat lying on its side and lawsuits being filed in Miami, we ought to have a special compensation fund. That's up to the policymakers. I have great confidence in policymakers deciding whether the political litmus test justifies setting up a program like that next time. There was no 9/11 fund for Katrina. 1,000 people died. There was no 9/11 fund for those horrible tornadoes last year in Joplin and Tuscaloosa. There was no 9/11 fund. None. I think policymakers, basically, whether it's political pressure or a philosophic sense of egalitarianism, policymakers are very reluctant to do this type of thing. Wisely so. Wisely so. The 9/11 reenactment was a miracle. In the lame duck session, Congress decided, there are all these responders who missed the deadline under the original Feinberg program because they didn't manifest a physical injury till after the fund expired. Elementary fairness, let's give them the money. I don't know. They didn't write it that way. She was going to have a lot of headaches with that legislation. But my answer to John Stossel is basically I punt by saying, if your elected representatives think there ought to be a special program, there ought to be a special program. That's the answer to Peter Schuck's criticism, you see. If policymakers say, Mr. Schuck, I know how rare these things are, and I know you think it's a bad idea for one program for some and others don't have it, but this is different. We have decided it's different. Who am I to question Congress's decision on that?
Professor Brickman, please. Please wait for the mic.
Ken, you're in competition with the lawyers in the MDL for claimants. Apparently you're doing a pretty good job. Is there some characteristic that distinguishes the group coming your way, accepting the BP money, versus those that are staying with the litigation? And second, do you have any comment on the attempt by the plaintiff lawyers in the MDL to tax the awards you're making, a 6% tax, so that they can feed their children?
Lester, if you think that latter question is a subject for my jurisdiction, you are crazy. You're asking me to comment on the 6% holdback ordered by the court for the lawyers in the MDL. The court has issued its order. I will follow the court's order. The union won the Civil War. I mean, that's a federal court. I'm not about to question the court, and I don't think I should. That's a decision the court's made. I'll honor that 6% holdback. Now, the characteristic of people coming to the fund rather than the MDL, not entirely, but a good deal of the people filing with me don't have lawyers, you see. They don't have lawyers. Fishermen, crabbers, shrimpers, hotel operators, restaurateurs, dentists, chiropractors, veterinarians, the Oslo, Norway guy. I mean, most of them, not all. Some lawyers are very active in the GCCF. But I would say one characteristic that, by definition, separates the two groups is the number of people who have filed with me and the GCCF without legal assistance. We'll provide legal assistance. The judge ordered me to provide legal assistance, and I will, but that's one of the characteristics.
Sheila Birnbaum.
Ken, I think everybody in this city and in this room and in this country owes you a real debt. I mean, no one really understands that you had to get people to come into this fund. The new fund is different. I have to try to keep people out of the fund. But you had to sit down with these families and their lawyers and convince them that this was in their family's best interest. It wasn't that they trusted you or the fund. You created an atmosphere that was very unique. And you started it all from scratch. There was nothing. There was no examples. There was no historical way of setting this up. And from nothing, you created something that was very valuable, that really gave solace, income, and closure to thousands of families. And when Mr. Stossel asked, what was the difference between the people in the fund and in the court? I know all the awards. And some did better and some did worse. But we applied a totally different standard than the fund did. And a lot of high earners who would have gotten very little because they had very high life insurance policies, and so they didn't go into the fund, got very high numbers in the tort system because no one looked at life insurance, and they were very high earners with families. Other people should have gone into the fund because they might have done better in the fund. But I don't think you can ever compare the two systems. What really happened was you may have saved the airlines, all the people, all the other money and the problems that would have arisen if 5,000 more people would have gone into the tort system. So we all owe you a real incredible debt of gratitude.
So from one of the speakers' honored guest to the other, Professor Peter Schuck, you have a question? Please wait for the mic, Professor.
I agree with your defense of the 9/11 fund. That is to say, it was special, it was unique, the members of Congress felt it, and people in the United States felt it, so I acknowledge that then and now. But my question has actually partly been answered. When I put up my hand, I wanted to ask about the percentage of the claimants in both the 9/11 fund and the Gulf fund who had lawyers, and what distinguished them from the others. You partly answered that. You were comparing the MDL to the Gulf facility.
Let me just say about lawyers. First of all, the lawyers in 9/11, as you all know, I think, the 9/11 fund would have never been as successful as it was without active pro bono legal assistance from the trial bar. Fabulous. Fabulous. In BP, when you have over 1 million claims, some people have lawyers that they chose. Some people ask for lawyers, and we give them pro bono assistance through the Mississippi Justice Center. Some people think lawyers are anathema. They don't want a lawyer. They want to just file a claim and do it themselves. Whatever. I don't know how many of the 1 million people who filed have a lawyer. I could get, eventually, we'll have that statistic. Maybe I should have had it today. But one thing is clear. If we decide that a particular type of claimant with a good advocate, a lawyer, will get X, we will do our best to make sure that a rising tide raises all ships. You can't give a claimant with a lawyer $100 and a claimant that has the same type claim without a lawyer $50. that disparity will destroy the credibility of the program. So I'd like to think, I know in 9/11 this worked, that if we make decisions because of lawyer advocacy, that decision, that policy decision, will benefit everybody.
Nicole Gelinas.
Yes, 2 months into the BP gusher, David Cameron visited Washington, and while President Obama was standing next to him, he said that BP was a very important company to Britain and that essentially it wasn't going anywhere. Do you think that this type of joint Western government endorsement of your viability, do you think $20 billion is a pretty reasonable price to pay for that, especially since you have to amortize it till the end of time? And if so, does that make it more likely that we'll see these in the future? A lot of big companies might pay $20 billion for prime ministers to say you're not going out of business ever.
That's a rather skeptical view of the world, I suppose. But let me just say this. I don't know where the 20 billion number came from. I think my own personal view is if BP had this to do over again, they would simply say, whatever it costs, we'll pay for it. Because here's what's going to happen. Everybody knows this. You pick up the newspaper. I'll end up probably spending, I'm guessing, it could be a little more or less, let's say $7 billion to pay all legitimate claims. Now, out of the $20 billion comes other money, other costs. Local and state cleanup costs come out of that $20 billion. Government claims by state and local governments for tax loss, tax revenue that was lost, that comes out of the fund. But what I'm seeing in Washington now is a concerted effort by Gulf Coast senators and congressmen. Well, whatever's left over should not go back to BP. It ought to be used for Gulf Coast restoration. And so I think that there's going to be a debate over whether or not, whatever the shortfall, well, didn't BP promise, well, there's plenty that ought to be done with the remainder, rather than go back to BP. The other point that ought to be made, it's easy, John knows this, it's easy in the press to say, the White House sort of compelled BP to do this. Don't be too sure. Don't be too sure. Maybe, I don't know, I wasn't in the White House. It's pretty hard to say no to the president, especially in the prime minister. But look at the other side of the ledger, what BP did get out of this. There are an awful lot of permits that they need from federal regulatory agencies to drill in the Gulf. They've got 225,000 total releases from litigation. I mean, I'll be very interested in the next few months to find out how many people litigating in the MDL in New Orleans ought to be dropped on the ground that I'm already holding their release. They're double filed. I mean, BP, I guess, from what I read, made a business decision. Business. We want to be a good corporate citizen. We don't want 22 years of Exxon Valdez type litigation. We want to get out of the courtroom. We want to get on with our life. We are not in the claims litigation business. And we have a lot of money. I think that it appears to me, you may be right, that one added factor was to get a political blessing from people who a political blessing may mean a great deal to their bottom line. But I think, frankly, BP, for a lot of reasons that you guys know about, it's not all, from the White House. There's also some business decisions, strategic decisions, that went into this decision. Gee, we saw what happened with Exxon Valdez. We don't want that with us. Let's think out of the box and do it a different way. And that's exactly what they did. And I'm saying maybe that was one more factor that led them to get a slap on instead of on the wrist, to get an arm around them from both the President of the United States and the Prime Minister of Great Britain.
with that, I'm going to call this session to close. I'd like to give a very, very hearty thank you to our guest, Mr. Kenneth Feinberg.
Just one thing, thank you very much. I just want to commend the Manhattan Institute. The Institute is engaged in lunches like this and discussions and panels debating these public policy issues. It's very, very difficult, you know this, to get a real substantive debate. You got to go to Shuck's classroom. If you really want to get a real substantive debate in all sorts of areas, I just, the minute the Manhattan Institute invited me, I jumped at the chance to come here and engage in this type of debate and see Michael Feinberg. So thank you.
I think it is clear how fortunate we are to believe in the power of ideas.
Supply the common sense and the fresh thinking of the Manhattan Institute.